Yeah. So many lies that you hear from the net, they don't get her respect. She reporting the truth, not a check. You want an unbiased opinion straight from the chest, not a bit of accomplice or someone here for a check. Tune in, these are thoughts from a lawyer on a mission who goes so hard it's like she works on commission. Trolls in the comments might say she tripping cause they lack the knowledge. They don't know they missing. Got a couple current events that you like. Wanna know about law from the eyes. Tired of all these blogs running lies because they agendas are disguised. Tune in to the intellect, cause I'm sure y'all missing all the facts of the case that she steady is gifting. Someone here for the people, man, it's so uplifting. If you ain't subscribed yet, then you just omitting facts.
Hello, everyone. It is Pam Esquire, also known as Your Law Intellect. Welcome. If you are new here, welcome to all of the subscribers. Welcome back to all of the ones that have been rocking with me for a while. And happy Father's Day to all of the fathers out there. I hope that you enjoyed your day. Well, on today, on Father's Day, while some of you all were drinking your favorite beverage and smoking your favorite cigar and putting your favorite meat on the barbecue grill, Diddy's team was out here working. So, as many of you guys know, there has been an issue with one of the jurors number 6, and we've been trying to figure out what has been going on. So, initially, as I reported on Friday, according to the tweets, the judge said, we're not gonna we don't think it's any bias, so we're just not gonna let we're not gonna remove juror number 6. We're gonna let him stay. Ask Sean Combs, hey, would you waive the appellate review or your appellate right? He said, yeah, I'll waive it, just keep him on here. And the court was like, cool. Well, it sounds like the AUSA was beating on tables and stuff and was upset. And so somehow, in about face, the judge was like, well, what I'm going to do, and we read that on Friday as well, what I'm going to do is, I believe that there is an issue. And so I am going to tell juror number 6 not to come back on Monday. And then one by one, all the lawyers, like popcorn on Sean Combs' team, just started jumping up, giving their reasonings why they feel like he should be able to stay. They did say it was racial bias. People start throwing their 20, 30 years in. You know it's getting deep when the attorneys let you know how long they've been practicing and they ain't never heard nothing like this. So everyone was going in. Brian Steele had his word. Everybody almost on the team had something to say against this. So the judge basically said, well, I'm going to think about it. And if I change my mind over the weekend, I'll let everyone know. So in actuality, even though we thought that juror number 6 got removed, it is not final, I guess, because the judge said, well, I'm going to think about it. Just give me a minute. So he's being very, very indecisive. So what Diddy's team has done is on today, they filed a 14-page document explaining why they believe that he should remain. Now, there were different, I haven't been in the courtroom. Hopefully I get there before it's over, because it sounds like the government said tomorrow may be their last day. And so it looks like the defense may put on their case as soon as Tuesday. So that's probably going to knock out a whole week of testimony. So I don't know if I'm going to make it, but I'm definitely going to try. But nonetheless, they have filed this motion, this letter motion, and they're trying to basically windmill one last time, they being Diddy's team, on why this juror should stay. So what we're going to do is we're going to read it. I want you guys to make sure you hit that like button, subscribe to the channel if you haven't done so already. But I know this is a holiday. It's a very special holiday for the men, so I don't plan on being on here long unless you guys make me be on here long, okay? Also, keep an eye over there. We do have a goal, so y'all can hit the super chats or the super stickers if you are so inclined. It's not mandatory, of course, but it'll be nice. It'll be nice. Um, Menelik asterisk 7. I don't. I hope I read that correctly. Said their right to do so. The judge's method of asking about Sean's waiver, then dismissing the juror seems strategic. Yeah, because I was wondering, like, does that mean that now he can't talk about the bias if he were to be found guilty because he put his waiver on the record? I didn't see the whole transcript, so I didn't see the whole exchange. But I thought he was waiving his right if the judge, to come back later if he's found guilty. Because obviously there's an appellate attorney on there. Shapiro is an appellate attorney. She's the one that was appealing the bond motions. He has someone on his team that is proficient and very, very good at different areas. Cross, expert, the appellate attorney. I heard he also hired someone for the forfeiture portion. So Sean Combs has all of the attorneys to cover all the areas. So I was thinking the exact same thing. I'm like, so now he waived it and you're gonna kick him off. Is that gonna be a problem? Where the government can come back and say, oh, he waived it on the record. So perhaps it should have been a waiver contingent on, and I didn't see the whole transcript, contingent on whether they choose to leave him on there. But if they choose to take him off of there, then you're not waiving it. Maybe that's it. Maybe it should have been phrased a little better to cover just in case something like this happens. Thank you, Mrs. C, for the super chat. I appreciate that. So yeah, thank you so much. I appreciate that. So let's get into it, y'all. Again, hit the like button so we can get up in this algorithm. So, dear Judge Submarinian, the defense submits this letter in further support of its vigorous opposition to striking the juror, and they take away, the name, a black man. Mr. Combs will be substantially prejudiced by the dismissal of this juror, and because there is no factual basis to remove him under Fazio, the court lacks discretion to do so. Moreover, if the supposed inconsistencies in his answers to the court's questions were truly of concern, redaction. They also had some exhibits that are under seal, so we couldn't pull those. If the court strikes juror blank, we respectfully request that a mistrial be declared. So if you strike them, we want a mistrial. So they was working all weekend trying to do their research to see if this judge really has the discretion to do this, meaning it's up to him, or if this is something that is not discretional. So if you want to strike them, we want a mistrial based on the juror leaving. I know the judge is probably gonna say that's what alternates are for, which is there's several alternates, but it sounds like again there were inconsistencies that were reported about how many were on the juror. I think people were reporting the jurors and the alternates, so you didn't know who are the actual jurors that are making the deliberation, that are actually going to be seated in the back in the room to deliberate. We really didn't know who that was. So according to this, he's only one of two black men. So that's a problem to him. So they said, we're going to ask that you just do a mistrial if you choose to strike him. We understand that the court has refused to find any discriminatory motive in the government's actions with respect to its preemptory strikes or this motion. However, we respectfully and regrettably disagree. The government's motion must be evaluated in light of the entire history of this investigation and prosecution and not in isolation. Unfortunately, when considered against that background, it is impossible to believe that this motion is merely a good faith attempt to raise a valid question about the juror's integrity rather than an effort to take advantage of an opportunity to strike yet another black male from the jury. So they start out with A, there is no valid basis to dismiss this juror. To begin with, as the court noted during the morning session on Friday, it does not have discretion to remove a juror, quote, where there's a bias in the removal of the juror or where there would be prejudice to the defendant, with prejudice meaning that the discharge is without factual support or for a legally irrelevant reason. So they cited the transcript and also US v. Fazio. Here, there would be significant bias and prejudice to the defendant, and there is no factual support for dismissing the juror. First, there is no question Mr. Combs would be severely prejudiced if the juror in question were removed and replaced by the first alternate. We have previously pointed out that this juror is one of only two Black men in the jury, but it should also be noted that he is the juror who is perhaps most similar to Mr. Combs in other important ways. He is a Black man, then they redact the rest, so we don't know what that is. Moreover, this case involves serious charges of actual misconduct against women who were in relationships with Mr. Combs. As the opening statement and the witness testimony have revealed, the principal dispute between the parties is whether Cassie Ventura and Jane willingly participated in the actual activity at issue during their relationships with Mr. Combs for their own reasons and because they chose to do so, or whether, as the government claims, they were coerced. The fairness of the trial depends in part on having jurors with backgrounds similar to Mr. Combs share their perspective on the evidence with the other jurors and diverse backgrounds during deliberations. Removing this particular juror will deprive Mr. Combs of that important perspective. And it is no answer to simply say that there are other Black jurors or other males on the jury. Second, there is no factual support for the government's position or, respectfully, the court's statement Friday afternoon, which were in stark conflict with the court's apparent recognition Friday morning that the purported inconsistencies were likely completely benign. So, like I told you at first, I was like, oh, so they're gonna let the juror stay. Then it was like we scrolled down a little bit. Oh, the judge changed his mind and is gonna let the juror go and said to come back on Monday. As we explained at length in our letter on June 12th on this topic, there were no material inconsistencies with respect to anything this juror said during voir dire and in the June 9th colloquies, you know what I'm saying. And the juror's willingness to perform this public service and his civic duty should be considered a positive rather than a negative factor. There is no evidence whatsoever that he had an agenda or a bias in favor of either party, and no legitimate reason to jump to that conclusion. And what's crazy now is that people are doing videos saying that this juror is a plant because he's trying to keep him on there. No, he's one of two Black males. And one of two Black males in the area, probably born and raised in the area of which Sean Combs was raised in, may be more, I guess, relatable to what he's going, what, to just how he grew up, what's considered acceptable, what's not acceptable. So you try to get people that could kind of see where you're coming from. When you get a bunch of people that are not from your culture, your area, they can't even, some of the stuff they just don't even get. Now, I'm not saying by no stretch of the imagination that you wouldn't have white people that probably knew about all of this stuff, the kind of stuff that Sean Combs was engaged in. However, you do need diversity because what's supposed to happen in the jury room is you get to present why you come up with the conclusion of guilty, not guilty, and you may persuade people around you that may not look at it from your perspective, from your purview. So that's why diversity is very important, to the point where there's a lot of case law that if you don't have a diverse pool, you can try to appeal it. And there's actual case law on not having a jury of your peers because of that. Okay. All right. Indeed, the court had an opportunity to assess the juror's demeanor, not only during voir dire, but also at closer proximity in the robing room during the two conversations on June 9th. The court never suggested at that time or at any time before Friday afternoon it had any reason to doubt that the juror was doing his best to be forthright and honest with the court. During Friday morning session, after having reviewed both parties' submissions, including the government's lengthy quotes from the relevant transcript, the court indicated it was inclined to agree that there was an insufficient basis to find the juror was being deceitful and intentionally so, as the government charged. So this is what the court said. And so the defense's submission is really that the answers given, the nature of the inquiry, both in jury selection and during the current process, was vague enough so that the answers could easily be reconciled with each other. And the subject matter of what was being addressed is so far afield from the juror's performance of duties that that's not a reason to remove the juror. This is the judge talking. The real suggestion from the government as to the reason why the juror should be removed is because if you take the inference against the juror's credibility, there is a view that if you can't reconcile the answers and the juror was being deceitful and intentionally so, either in jury selection or in the robing room, then that would be grounds to disqualify the juror. For that for that to happen, we will need to have further inquiry with the juror because on the current record there's an insufficient basis to make that determination. And in terms of how we view the inquiry post jury selection, I think that there's a difference. I think that when we address these types of questions during the jury selection process, there may be an inkling or a suggestion that there's a reason to disqualify a juror for cause, and that has one standard. But it is before the exercise of preemptory challenges and impaneling of the jury, and so that has one standard. I think the defense's suggestion, they put this in bold because I think this is important for us to read. And I think it's consistent with a lot of the cases is that default actually flips once you have the jury actually in the box and you have a regular jury and alternates. At that point, you need something more to disqualify a juror. And the cases cited by both sides have situations presented that are far more extreme than what's been presented here. So it was just totally agreeing with the defense. Moreover, although the court indicated a preference for further inquiry, it specifically noted, quote, I think that it is likely that what we will hear will be a perfectly innocent explanation for the answers. And then it's in bold again, so pay attention. I don't think that they're irreconcilable. I think that for the reasons that the defense has stated, there's a way to reconcile the entire record, and that's in the transcript. The court also noted that the quote, only reason why this situation even came up is because of a statement that was made on the juror's own volition to jury department staff in a friendly and an offhand banter. So the court further observed, and there's perhaps an understandable way to reconcile all of these issues, which is that I believe that the question that was initially asked during voir dire, during the group proceeding, was where do you live? And then kind of who do you live with? But based on the answers that were being given by the group, it could have been that the juror thought, where do I live? I live in the Bronx. And that would be consistent with everything that we've heard because he indicated that he had moved out of the Bronx in the last 2 weeks, and there might be some ambiguity about how much time he was spending in each place, but that's at least what he said. As to the second question, he might have understood it to be who is in your family group. As to the question, he indicated his fiance and his baby daughter. And so you can reconcile these things, and given what we're talking about, which is where do you live and kind of basic questions, it would be surprising that someone would try to make up something about it. Maybe even if there was some inconsistency, it wouldn't rise to the level of removal of a juror, given the various constitutional and other rights that the defendant enjoys. So that was the court. The defense expressed concerns about any further inquiry because of the likely negative and intimidating impact it would have on the juror, especially after the government started suggesting a line of inquiry that could lead to a concern that the juror's employment was somehow in jeopardy. In response to the court's comments, the government ultimately stated, quote, that the most prudent thing to do to ensure the integrity of the proceedings would be have additional inquiry. It endorsed further fact finding, stating that such fact finding was necessary. To ensure the integrity of the proceeding, the court said it would consider the parties' argument and whether to conduct further inquiry later. In light of the discussion in the morning, the defense was stunned when the court announced at the end of the day, in stark contrast to its extensive earlier remarks about why there was, quote, an understandable way to reconcile, end quote, the jurors' answers, that it believed the juror was either, quote, unable to follow simple instructions and answer simple questions, end quote, or was, quote, shading the truth or being deceptive. And judge, this is a total different from the morning to the afternoon. Total different. A total about face. And would dismiss the juror without further inquiry. Respectfully, there is simply no evidence to support the court's very serious accusation or stated concern about the juror's ability to, quote, fairly and impartially apply the rules of law of the court to the facts of the case, to consider the evidence in a fair way, and to follow instructions of the court. Okay, I'm trying to see if I needed to read any footnote. Not really. The court later stated that when the juror said he had a New York license and still maintained his residence in the Bronx, this was somehow nefarious and suggested an effort to try to get into the jury. But the juror was already on the jury and had sat through over 4 weeks of trial. Having been willing to serve, which many citizens aren't, and have dutifully devoted all this time to attending the trial, why would a juror not want to complete his service? Why would he not emphasize that he is still a legal resident of New York, even if he spends several nights a week? Redaction. There is not a shred of evidence that he had a pre-existing agenda when responding to voir dire questions, as opposed to a willingness to do his civic duty, and the statements the court cited were made after weeks of service, not at the outset. That is true. Because, like, the trial sounds like it's about to be over in the next week and a half to 2 weeks. And this person has sat there the entire time. And then, because an offhanded comment, which may or may not question his residency or where he currently lives, even though he has a New York license and said he lived in the Bronx, now the government is pushing to get him kicked off of the jury, because apparently I think the next person, the first alternative, I think they said is a white guy or a white woman. It's somebody, okay, but I'm sure they'll get into it. But they're not black, whoever the alternate is. So okay, yeah, run these likes up, y'all. Okay, I'll try to see. Peace 4100 said those 5 prosecutor lady wants juror 6 out. They have said he makes face gestures that can influence the jury, and he lives in Bronx but visits his girlfriend and daughter in New Jersey. Said he smiles too much. They don't know what that man is thinking. Yes, the oldest white man. Yeah. I don't know. It's me says some folks are saying juror 6 made a distinct reaction when Mia was on the stand by putting his notepad aside like he's already made up his mind, prompted them to investigate him. Well, that's gonna be, I've heard people looking at making faces about Jane. Of course, the Brianna, we gonna get to that in a minute, because the jury instruction that's being proposed because the judge doesn't want to grant a mistrial, or that was his proposed solution, was for them to come up with a jury instruction that basically you're saying she was untruthful. I don't know if the judge is going to accept it. They haven't got to the charging instructions yet. Usually that's like a day that they start doing it, charging instructions, either after the court for the day or beforehand, or they'll take a whole day to do that and to go over jury instructions, and everyone argues the ones that they have issues with, because each side is going to try to get in some type of jury instruction the other side doesn't, and they got to come with their case law, and they got to argue. You have some special instructions that are predicated on case law that aren't necessarily in your standard jury instructions that they're going to go over. But yeah, it's starting to look a little interesting in this courtroom. I'm just saying. Hey, Shar, good to see you. You know, let me see if I see anything else. Oh, we got some super chats. Thank you so much. Granny the Great said, "Good evening. Thank you so much for the super chat." She also said, "Happy Father's Day, Deb. I hope you had a wonderful day." Oh, that's so nice. All right, let's go on, y'all. Let's get back into this scathing letter. Should the court exclude your blank on the current record, it will no doubt have a chilling effect on minority jurors' willingness to serve in the future, a step in the wrong direction. Because one of Diddy's attorneys did say, out of my 20, 30, 35, whatever amount of years he's been practicing, he said, I've never seen a jury this diverse. He says, so we're moving in the right direction. And now it feels like, Judge, we're just going backwards. So the government has previously argued that racial disparities in jury service exist because Black and Hispanic people disproportionately fail to respond to jury qualification questionnaires, and that's in US v. Slaughter. So apparently the minorities is like, I ain't got time to get paid $25 a day. Okay. I got to go to work and I'm busy, apparently. But I think it's going to change because it seems like there are more people that are interested in the legal process. The more we talk about it on YouTube, social media, period, or the more they stream trials, I think a lot of people are interested in cases of which they will probably want to do jury instruction before. I mean, do jury duty before. Because I know when I was younger, all you heard about how people didn't want to be on it. And so they're telling you all the tricks and tips to try to get off of it. But now it just seems like a lot of people are more interested in this process when they weren't before. And the good part about that is when you have the public that is interested in it, you can make changes can happen. You have more people to support changes happening. So I'm excited that people actually care and they went outside of Law and Order and all of the made up shows because our system don't necessarily work that way. I think that these type of cases are giving you an insight of what's in our legal system and how the system works. But Juror blank answered the call and dutifully performed what the court stated was tremendously important task, recognized by the Constitution itself. We should invite his service as well as the service of other potential jurors in his community, not discourage it. Third, if the bar is this low, then blankety blank, 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 redaction. We won't know what that says. Oh, okay. That was under seal. The government's motion continues a pattern of overreach, suggesting a discriminatory motive in challenging juror. Although the court denied our Batson challenge and said it found no basis to suggest the government had a discriminatory motive when it sought to strike juror blank, we believe that motive is supported not only by its remarkable decision to use 7 of its 9 preemptory strikes on Black jurors. Oh, wow. So, preemptory strikes, you have to have a reason. Well, you don't have to have a reason. Like, they'll say, is it for cause? And for causes, you could say that person knows the lawyer, or that person straight up said they hate my client and they can't be unbiased, and they can't be unbiased, period. So those are ways for cause. Your preemptory challenges you can use regardless to what. You don't have to have a reason. The reason is usually whispered between you and your co-counsels, if you have co-counsels, on why you want them to be off. So apparently, according to Diddy's team, 7 of their 9 preemptory strikes were on Black jurors. But also by the history of the investigation and prosecution, which has been characterized by extreme government overreach from the beginning. So then they say preemptory challenges during jury selection. The court accepted the government's proffered reason for its preemptory strikes of Black jurors as race neutral. Nonetheless, it is important to note that for many of these jurors, the purported reasons themselves were based on the jurors or their relatives. interactions with law enforcement, including prior convictions. But it is well documented that there is a long history of systematic discrimination that has led to mass incarceration of Black and Hispanic people in this country. That's the truth. And the discrimination in how law enforcement treats them in comparison with white people. And they got, see, Floyd v. City of New York. They have the case site, which was describing historic heightened police enforcement of Black and Hispanic people in this district. Moreover, a 2022 study of 3,200 innocent defendants exonerated in the U.S. since 1989 revealed that Black Americans are 7 times more likely than white Americans to be falsely convicted of serious crimes. Don't I beat that in your head? This is my wheelhouse. This is what I do. So yeah, they threw the statistics. Citing a prospective juror's former conviction or their relative's former conviction or the fact that they have had negative interactions with the police only reinforces the race discrimination that led to the over investigation and over prosecution of Blacks and other minorities in this country. People should not be precluded from serving on juries because of a prior conviction or a relative's prior conviction or the fact that they had a bad experience when the police stopped their car on a pretext or conducted a stop and frisk on a pretext. And you know, New York was, they were the godfather of stop and frisk. Indeed, if they had a negative experience with the justice system, there is a perspective that is important and useful for a diverse jury. For these reasons, in recent years, courts like the Washington state courts have implemented rules foreclosing the use of a preemptory because a juror has had prior contact with a law enforcement officer or has a, quote, close relationship with people who have been stopped, arrested, or convicted of a crime. So that's actually in the Washington court rules. Here, the government justified several of its strikes on this sort of basis. For instance, it said one reason for the first strike was that the juror had a fiance that served 4 years in prison for a drug conviction. So I guess that's why they struck that person. A reason supplied for the second strike was that, quote, he had been arrested 3 times, including for harassing a police officer. The fourth strike was juror, quote, whose ex-husband has spent 21 years in prison for attempted unaliving and remained close with him and had a brother who had been incarcerated for 2 years based on a drug conviction. The government justified its fifth strike in part on the basis that the juror had 2 brothers who each did time in prison for felony convictions. Another strike cited inconsistent explanations of interactions with the police. So these were their reasons why they wanted to strike all these Black folks. History of investigation and prosecution. So they probably gonna get into all the stuff that they don't like about what they did with Diddy. Okay. Thank you, Cece, for the super sticker. Miss T, thank you so much for the super chat. Stormy, thank you so much. You guys, please make sure you hit that like button. I appreciate it. Hey, Dennis, good to see you. Juror number 6, Peace 4100 said, juror number 6 is a Black man, is a correction officer in New York. His license is New York, and his mail goes to his home in Bronx. They've had judge question him 2 times. Could have been nervous. Absolutely, I would have been. My Bell said, oh, so they know it's discrimination. Melanie said, I wish the sentencing was just as simple as the way the crime was committed. Yes, Pink Goddess. She asked, was this the juror that was frequently late? So he was running his mouth and staff heard him. Yes, this is him. They said he was late all the time anyway. That is him. Kia Elder 305 said, I don't know how any of this stuff works anymore because that the president is a convicted felon. All the rules should go out the window. Anyone should be able to be on a jury. So interesting enough, Kia, if you are a convicted felon, like just say hypothetically Diddy goes to prison, he can come out and he can run for Congress. Like he can run to be he could run for all of that. He can run to be president. There's only two reasons why they have that you are not supposed to be able to run, which is why people were filing lawsuits because they used the insurrection as a reason, because that's in the Constitution. So, yes, if you are a convicted felon, you can be in a federal political office. Now, in many states, they can ban you from being able to run. So, like in the state of Michigan, when we had our issues with Kwame Kilpatrick and a couple other politicians, they changed our constitution to add that if you are convicted of any crimes related to theft, dishonesty, fraud, financial, what that type of those type of convictions, you cannot run for, I think it's 20 years. But you have some states that say you can never run. So it's interesting that we've had people that have run for state office and then people challenge it because of their convictions and they get kicked off the ballot. But then you have people, the same person can run for Congress and go up to the Capitol over there in Washington and they're just fine. That's just the way the law is. So a lot of people will say the president got 5,000 felonies and all of that. It's nothing. Of course, I'm exaggerating, but there's nothing that is illegal about that. Um, However, both addresses are still valid for him to serve. He just should have answered the question exactly as such. I'm part-time there and part-time here. So, okay. All right. History of the investigation. For starters, it is notable that Mr. Combs, one of the most successful and self made Black men in America, and a person who was an icon, not just in the Black community, but in the music industry, the fashion industry, and otherwise, was indicted by the SDNY Civil Rights Unit. When the unit was established, former U.S. Attorney Damian Williams was quoted as saying, quote, white supremacist groups are on the march. Anti-Semitism is on the march. Anti-Asian violence is on the march. Abuse of the most vulnerable in our society is on the march. But this prosecution has nothing to do with civil rights enforcement. What is being prosecuted is allegations about private sexual activity Mr. Combs engaged in with two of his former girlfriends and third parties. All of this was part of a coordinated effort to try to destroy one of the most successful Black men in American history. All of Mr. Combs' ventures are entirely legitimate, and the government has never suggested otherwise. Instead, the government's case is all about his personal life and what he and his romantic partners have done in the privacy of the bedroom. As the trial has shown, the most significant evidence against Mr. Combs involves domestic violence, incidents normally dealt with by local authorities or family court. Yet the prosecutors have made a federal, quote, civil rights case out of how Mr. Combs and his former girlfriends conducted their private ex lives. The theory of prosecution not only has nothing to do with civil rights enforcement, but it is also unprecedented. Indeed, we are unaware of any other federal criminal charge charging racketeering or ex trafficking based on allegations that a man and his past long term adult girlfriend sometimes brought a third party, a male escort or entertainer, into their actual relationship. Since its inception, the case has been rife with overreach and unusually aggressive tactics normally reserved for prosecutions of violent gangs, organized crimes, and terrorism. So then they're giving bullet points. The purported victims never complained to law enforcement. Ms. Ventura's lawsuit was settled for $20 million and she never made any complaint to SDNY or any other law enforcement agency, nor did Jane. Indeed, the government labeled her a victim in blank and bail arguments long before it had ever interviewed her. And she claims to have testified only because she was compelled to by subpoena. Second bullet point, the government has devoted enormous resources to this case. The undersigned are not aware of any other recent case involving more than 5 AUSAs, and here we have 6 at trial, along with 2 filter teams, AUSAs, and multiple actively involved supervisors. Additionally, the Department of Homeland Security assigned multiple agents to the case, and numerous other agents have assisted at various points, including hundreds of heavily armed agents in combat gear who executed military style raids, complete with armored vehicles, on Mr. Combs' Los Angeles and Miami homes in March 2024. And the government, who apparently retained a highly paid jury consultant in this case, which is exceedingly rare for the government to do, a consultant who may well be advising the prosecutors in connection with the instant motion. So they think since they got a jury consultant they hired, so they doing a whole lot in order to try to come against Diddy's team. I'm sure his team had jury consultants, and we see that a lot on the defense side when it comes to criminal, but they're saying the government actually did it. So they're believing that they're suggesting rather that their jury consultant might have been looking at old boy like, yeah, we got to get him off of here. You guys need to try to find a way, dig into your research, pull out your law books, dust off your books. You need to get him up off of here. The SDNY refused to engage with defense counsel during the investigation. Mr. Combs' lawyer approached prosecutors as soon as they learned of the investigation, even before the warrants were executed, and requested an opportunity to meet. Yet, the SDNY refused them and repeatedly refused thereafter to engage with counsel substantively throughout the investigation and leading up to Mr. Combs' arrest in September 2024. The prosecutors also refused to allow Mr. Combs to voluntarily surrender, presumably to create another media spectacle like the one orchestrated during the raids discussed below. Next point, the SDNY used misrepresentations and material omissions in warrant applications. Although the court denied our Frank's motion, the defense has documented how the SDNY obtained the March 2024 warrants to search Mr. Combs' homes, person, and all his electronic devices using materially misleading applications. They omitted extensive evidence undercutting the credibility of Ms. Ventura and other witnesses the warrant application relied on to establish probable cause. For instance, when obtaining the warrants, the government completely disregarded extensive evidence then in its possession, showing Mr. Combs and Ms. Ventura's relationship was, though at times toxic, consensual, and loving. The application also relied on several other witnesses the prosecutors later admitted were not credible. These witnesses were part of a feeding frenzy of grifters who were trying to extract money from Combs after the Ventura lawsuit became public. Yet, the prosecutors failed to disclose the financial motives of these witnesses and concealed exculpatory evidence that the government had in its possession when it sought the warrant. Next point. Investigators used excessive force and created a media circus during the raids of Combs' home. The search warrants were executed in a manner calculated to garner press attention, sensationalize the case, falsely portray Mr. Combs as dangerous, and taint any future jury pool. Now, what I will say is, what was out here in the media, this is why I told everyone, like, he is innocent until proven guilty beyond a reasonable doubt, and I kept reiterating it because a lot of these stories out here and a lot of these bloggers and a lot of bone carriers that were coming with this stuff has nothing to do with this case. It's never been brought up in the case. When I looked at the indictment, I was like, oh, they're gonna supersede it. That's what I was thinking. They're gonna supersede it and add a bunch of this other stuff. You had everyone going on platform. The crazy part, a lot of these people worked for Diddy and they got money. Then when they left because he fired them or he wasn't getting their job back, a lot of them are still trying to make money by starting channels or, acting like they got so much inside information, doing 1,000 interviews when nobody was doing none of this when he was out on the street. So it does seem a bit like interesting that we heard about lace baby oil. We heard about white parties where it was going to be celebrities and everybody was going to be in rooms having all type of crazy stuff going on. We thought we was going to get a whole list of some of your faves. And it turned out that literally this whole case is about people he had relationships with, be it an open relationship, a closed relationship. He cheated in that relationship. And then for this one with Jane, it sounds like he said, listen, I'm out here. Do you want to be on my roster or not? Because it's too much of a headache to be promising these women that I'm going to be faithful when I know I'm not. She chose to be on the team and she wanted to be the captain. All right. And because she wasn't the captain, she was a bench player. She wasn't feeling it. And that's what we've learned through this trial, which is totally different from what we have been seeing on the internet for I don't know how long through the summer. You said he tells the women he's polyamorous. So let's go on. Shar Powell said the Diddy son hurt his case by bragging about the house they missed. I don't know. Some people were saying I've seen something about some phone they found, but it wasn't like it was a. I don't think it was a hidden phone like it's being portrayed. I think it was more like of they missed it. Like when they raided the homes, they missed it, and he may have talked about like, yeah, they'd have missed the device, you know. So yeah. So I don't know. Anthony said they turning this into a race case. This motion for mistrials and extreme good faith. Great job, defense. Yeah, I try, kid Elder 305. I try. So this is the problem too with this. So you had like then a lot of the people I also noticed the ex-workers that were like the crux of Jane's case, none of them are testifying that I saw. You saw the Punisher testify, and he lived in New York. He's done a couple interviews. He lived in New York, and he only dealt with them in New York. So that's not even the crossing state lines for trafficking or any of that. So I think he's trying to understand why he was even called in. You know, he's doing interviews. So even though Cassius say I did it, we did it in Miami, we did it here, we did it there, it would have to be, I think Cabral, when it came to Jane, Cabral or Sly, I think he was from Atlanta. So he did fly over all the time, but you see that even she suggested Cabral to she being Jane suggested Cabral to the celebrity that everybody's trying to figure out who it is over in Vegas that Diddy had nothing to do with. So she reached out to Cabral. She DM'd Cabral. She said that was the person she preferred when she didn't like some of the guys that came in that she wasn't attracted to because she had a preference. Even though she's saying, you know, she was coerced, she has a preference. So when she couldn't do it and was like, I just can't do it. I just can't do it. She would text and call Cabral. And a lot of the money, this is why the government was trying to emphasize that Diddy paid her back because she was paying for it. So they got to attach it to Diddy because she was actually paying for it. So she'll say, yeah, I got my money back. I booked the flights. They probably got information that she was the one booked the flights. It was in her name or used her card. So she's saying Diddy paid her back for every time she did it. So honestly, a lot of the information we got shows more of the women actually being involved, getting these people to go across state lines. So we'll see how this goes and how they end up handling it. T. Ryle said this whole case is a bunch of BS. The overall results is to teach Diddy a lesson. He stepped on the wrong foot or feet. Too many people would be exposed and they can't allow that to happen. And piggybacking off of that as well for Diddy, he's going to learn you can't treat people any old kind of way. Regardless, I'm not saying that everything was criminal. I'm not debating that, but it was clear he wasn't a nice person. Don't know how he is today, but I'm saying in the past, he was not a nice person. We saw it on television. Just because you have the authority, the ability, and the finances doesn't mean that you treat people bad. Just don't like people that don't treat people right. And obviously, he did not treat people right. So you had some people that were willing to take the fifth, to say, I'm pleading the fifth, get their immunity and testify. When you look at Jane, she started keeping all these detailed case notes after she saw Cassie's case. And then she also started there was one a violent incident with Diddy, and she started it. So it did open the floodgates. You had the balcony incident that nobody can get right on what really happened, or if it even happened, or if it was made up, and it was some collaboration. Yeah, we gonna get it. You go ahead and sue, get you a couple of dollars. or whatever it is. We had the balcony incident, of which nobody can get straight, of which she tried to sue after Cassie's lawsuit. But she told Cassie she didn't want to be her name in the lawsuit, in her lawsuit. But you gonna go behind the scenes, get you an attorney, Blackburn, to try to do a demand to get $10 million. So yeah. So yeah. Let's get back to this reading. All right. So they're using this time, I think, to let everybody know how they feel like Diddy was being wronged and that this all was racially motivated and trying to get rid of. You had 7 out of 9 preemptory challenges, and you eliminating black people. And then this juror number 6, which is one of the only black males, it's like one of 2 black males. They're allegedly, I guess, not allegedly, obviously, they're trying to get rid of them. So okay, so they have investigators used excessive force and created a media circus during the raids of Combs' homes. If you guys, anybody follows Misha, who is Justin's mom, she actually got an attorney because of the excessiveness, the excessive force that happened during the raids. They knew Diddy wasn't there. They had been watching the homes. They waited till he was gone. And then they raided the homes, knew the kids were there. And they had kids, I guess they had them in handcuffs and big long guns and all type of stuff, of which Misha showed a video of them because they had the cameras from the inside of the home of how they were treating them. So this was part of what the problem was too, according to the defense. The search warrants were executed in a manner calculated to garner press attention, sensationalize the case, falsely portray Mr. Combs as dangerous, and taint the future jury pool. Agents leaked the government's plan to the press in advance to maximize media coverage and put on a show. Now, there was cameras and media already there when they arrived, so the agents used excessive force against Mr. Combs' children who were in his home doing nothing wrong. One agent held a semi-automatic rifle to the head of Christian Combs, even though he was visibly complying with the agent's demands. Another had a semi-automatic rifle with a laser sight trained and the orange dot visible on the middle of the chest of Justin Combs, who was also complying with agents' instructions. The agents then handcuffed them and paraded them in front of news cameras and a TV helicopter invited by DHS, who are waiting to get salacious footage of this staged perp walk and two innocent young men. The next bullet point: investigators leaked a steady drumbeat of false and prejudicial information to the press until the court issued a broad gag order opposed by the government. Throughout most of 2024, DHS agents repeatedly leaked information about the investigation to the media, including extensive amounts of highly prejudicial and false information about minors. See, this is what I was just talking about minors, ex dungeons, cameras in bedrooms, and a host of other prejudicial information that has caused online conspiracy theories to multiply. As the court is aware, the prosecutors repeatedly denied that these leaks emanated from its case team by describing that team in an artificially limited way, and even opposed a request for a gag order that would prohibit all DHS agents, not just the limited few SDNY claimed were on the case team, from leaking sensitive information about the case. While the litigation was ongoing, the leaks continued unabated. It was only after the court issued the broader gag order the defense sought that the leaks finally ceased, long after the jury pool had been deeply tainted. Since then, the government has repeatedly invoked the gag order and local rule 23.1 to prevent the defense, which has a right to try to combat the unfair tsunami of nonstop negative coverage from the media engagement. At the same time, the government has failed to oppose in any way the numerous apparent violations of the rule by alleged victims and their counsel. Wow. Next bullet point: prosecutors insisted on detaining Combs even though he did not present a risk of flight or danger. They just spent today just airing out all their grievances. And another thing, The prosecutors insisted on detaining Mr. Combs, even though he offered to surrender, traveled to New York once he learned he would be charged, and obviously was not a flight risk. They also misled the courts that held the initial detention hearing. For instance, they told the district court the CNN video refuted Mr. Combs' account of the Intercontinental event. In parens, that the incident occurred after the couple had an argument over Mr. Combs' relationship, and that involved a phone. End quote. End quote. In paren. They said that was, quote, just not what happened, and, quote, just another cover up, just more lies. Even though nothing in the trial evidence contradicts the claim that the fight occurred because of jealousy in the relationship, they cited a third victim, Gina. Gina done disappeared. She's still posting on Instagram and her stories, but she done went on. She said, I won't be testifying on either side. She said, who the prosecutors have entirely dropped from the case. So apparently they cited her as one of the reasons, and they haven't even used her to keep him in on bond at the bond here. Keep him in jail instead of issuing a bond. And now they dropped Gina from the case, but they used her in their arguments to try to keep Diddy in jail during this whole time. Prosecutors surveilled Combs in jail and invaded the defense camp. The prosecutors next took advantage of Mr. Combs' incarceration to spy on him and invade the defense camp, violating his attorney-client privilege and his First Amendment rights. As the court's aware, shortly after Mr. Combs was detained, a BOP investigator began monitoring his communications, including calls with his attorneys and sharing information with prosecutors. Now that is so foul. During an allegedly unrelated October 2024 general sweep at MDC Brooklyn for contraband and evidence of corruption, agents completed their search of certain parts of that facility and asked SDNY whether or not they should continue their effort and search Mr. Combs' unit. An SDNY supervisor told them to search Mr. Combs' unit because of the government's interest in Mr. Combs specifically, and law enforcement agents proceeded to do so. During the ensuing search, the investigators who had been working with the prosecutors confirmed there was no contraband among Mr. Combs' personal effects, but nonetheless rifled through his possessions and photographed Mr. Combs' notes reflecting conversations with his attorneys and ideas for defense strategy. The investigator then told a member of the case team about the notes and turned them over to SDNY, which tried to use them to oppose a renewed bail application, claiming they showed Mr. Combs was trying to obstruct justice. The court granted a defense application to order the prosecutors on the case team to destroy their copies of the privileged notes. So, as one of the, headlines that were conspiracy and sensationalized, they cited a headline titled "Diddy as bad as Epstein," says officer who saw his ex rooms hidden cameras during Miami mansion raid. Remember, like the New York Times and the New York Post and all of them, they had articles where these people that were alleging they were agents but wanted to be anonymous was giving these quotes and information, and that's part of what Diddy's team was trying to submit, that about the media, them leaking stuff to the media. Okay. Prosecutors violated Combs' free speech rights. The prosecutors continued their spying and next argued that Mr. Combs' other writings and communications from MDC supposedly involved instruction, even though these materials were clearly protected by the First and Sixth Amendment. Some reflected his participation in defense efforts to obtain material that could be used to challenge the credibility of the government's witnesses. Other writings describe Mr. Combs' view that the prosecution is racist and his desire to get that message out to counter all the negative media about the case. The SDNY even went so far as to claim Mr. Combs' request that his children post a happy birthday message to him on Instagram was an effort to obstruct justice, because Mr. Combs hoped it would present him in a more positive light to the public and undo some of the taint to the jury pool caused by all the negative publicity gained up by the government and civil plaintiffs' attorneys. So in the footnote, they say the court apparently recognized that these communications were constitutionally protected, but did not resolve the question, instead choosing not to rely on these arguments by the prosecution when it continued detention. They said, and another thing, prosecutors abused a filter team to access privileged material. The government's invasion of the attorney-client privilege in the defense camp has not been limited to its seizure of Mr. Combs' notes. Throughout the case, SDNY has misused a purported filter team, which was supposed to ensure that prosecutors handled the case were not exposed to privileged material on the numerous electronic devices and internet accounts the government has seized and searched. Following execution of the March 2024 warrants, defense counsel provided the prosecutors with the names of attorneys who had represented Mr. Combs and his businesses so that potentially privileged material could be segregated from the case prosecutors. Our understanding was that a filter team would not provide any potentially privileged material to the case prosecutors without first affording defense counsel the opportunity to review the material so that counsel could assert privilege if necessary, and so that any privilege disputes could be resolved by the court in camera. Instead, the filter team has repeatedly passed along potentially privileged information without first seeking our input, requiring us to claw back privileged communication after the case team had already been tainted by exposure to these material. Good God, they got more. They was mad today. They got more. They're trying to humble him by all means. That's from T. Riels. Queen Brielle said Diddy and Mark lied about the legal pad during the hearing that was related to the filter team. Yeah, it was not the way it was explained. So the lie, though, that they're saying is that what you do is like, say, for instance, I send mail. They can see from my address and my firm that it's probably from a lawyer, but I usually write legal mail. And that means you're not supposed to open it up. Now, what I will say in the prisons is that oftentimes I'll get emails. They'll say, "Oh, it was tore up on the way in," or your paper looks like it might have a little stain on it, and we got drug problems in here. So they will find different reasons as to why they're opening your legal mail. So that's why I don't even send legal mail anymore, because it was just too many coinky dinks of people having to open your mail. And I never I'll do in-person visits more for that reason. So I never really sent anything that I cared about like that. It may have been like a pleading or judge's order or something like that, or something they asked me to get, or interview or whatever. It really is never that big of a deal, but I know that does happen. So what Diddy did was, you're supposed to put, I guess, privilege on the envelope or the notebooks or folder or whatever, so you can differentiate to know that it's privilege. So what the investigator did was said, whoever this agent was, they took pictures and they said none of the pictures that they had, I guess, that they took said privilege, because he did have some that said attorney-client privilege. So the attorney probably told him that. But these notepads didn't have it on there. So what he did was, when they went to court, because they knew the judge's mindset, it looks like they wrote privilege on some notepads maybe after the fact, is what it was looking like, and the judge caught him on it. Was like, "No, you just wrote this on here. This was not written on her when they took it." So it wasn't that the content was not necessarily privileged. It was just Agnifilo misrepresented to the court that all of these notepads had privilege on it, and they still took pictures anyway. So it really wasn't even the content that was the issue. It was that misrepresentation that Diddy probably went back in there and was like, "What you say? Put privilege on my notebook? Shoot, privilege." And it was after the fact. So yeah. Victoria said, "I know people hate him, but people should also take notice, because if they would do the black man like this with a ton of resources, one who is without don't have a shot in hell." And that's what it's showing. But again, this case is an eye opener to a lot of people, and a lot of people, they don't like him. He wasn't my fave when he came on here. I like some of his music, but I never liked how he treated people, and the arrogance and the perceived, just how he treated people. I just did not like that. So for me, that was just an issue. And I ain't know nothing about domestic violence. I didn't know about, I had inclinations by some of his behaviors that he may have some drug issues, but I didn't really know for sure if it was or not. This is something we are all learning in the whole world together. So, or about an alleged OD where he went to the hospital and all of that after going to the bunny ranch. Like, we didn't know all this stuff. He had people around him. Like, you're paying your assistants to clean up hotel rooms after the fact to avoid pictures being taken from and getting the TMZ to pay for the pictures or whatever. So he covered his tracks very, very well with the resources and money that he had. But these are things that do happen. And unfortunately, a lot of court appointed attorneys are overwhelmed. So they don't have this type of time. These individuals, Diddy is paying them to focus on him. If they have other attorneys in the firm, they're the ones doing everything else. But they're not free until July to take cases. That's when they'll be free. And then he already has his appellate attorney. So the appellate attorney obviously is still going to be working on it if needed, you know. Thank you so much, Stormy, for the super chat. I appreciate that. Hey, Ray. Good to see you. Thank you for being a member. You know what's up. Hey, Patrina. Good to see you. She said, keep up the good work. I'm trying, sis. I'm trying. Listen, well, you know. Epstein's situation could be a whole lot within itself. M.O. Walker said, not a Diddy fan, but this is not right. Definitely overreach. Thank you so much. I appreciate that. You said, thank you for being balanced and reporting. I try. Intran said, Pam, so if a juror just tells DMV they live somewhere to get their license mailed there, then they actually do. I thought what the juror did is referred to as DMV fraud. He didn't say he didn't live in Bronx. He said he had a girlfriend and he has a daughter that lives in New Jersey. So what I have learned as marrying somebody from New Jersey is that oftentimes they travel from New Jersey to New York. Like when I go to New Jersey to see family, we always go to New York. So that's not uncommon that perhaps you crossing that bridge and you're coming, you know, to back and forth. So he said in the last couple of weeks, I guess, he must have been probably explaining why he was late. If I were to suspect, he's probably explained to a guard why he was late and said he's coming from New Jersey and, you know, whatever reason. He might have said, because, you know, I stay with my girlfriend in New Jersey. He probably said something like that because he was late all the time. And, you know, that bridge is no joke in the morning. So I'm thinking that's probably what happened, is that he was just like, man, I'm trying to get here. I'm sorry that the court is waiting on me, but you know, I'm coming from New Jersey. And then that made you inquire into, well, why are you coming from New Jersey? And you have to be a resident here in New York in order to be on this here jury. So that's probably what happened. T. Rael said, more money, more problems, like Biggie and Diddy said. Yeah. Yeah, they said something. I don't know if that's what he said. He said he been there for 2 weeks, but he lives in the Bronx. And the judge said that that's not a problem if you actually live still live in New York. There's a lot of people with dual residency between the two. I mean, y'all remember Whitehead? He was living in New Jersey, but he ran for, what did he run for? Whatever, over there in New York. He ran for something over in New York. So that's what it sounded like, Mo Walker, that his legal residence is in New York, but he spends time in New Jersey because he has a girlfriend there. So yeah. Yeah, Brooklyn Borough president. That's what he was doing. He was running for. I choose Joy. Carlotta said the judge said he is inconsistent when given a chance to explain. We'll see. But the judge changed his mind. Hey, Andrew, good to see you, sis. The judge earlier said that it didn't rise to the level of excluding him. And then by the end of that day, he was like, we're just going to let him go because we feel like it's either one or two things, or that he doesn't understand what the questions being asked, or he was being deceptive. And it seems like he just wants to be on the jury. So we're going to tell him not to come back Monday. So if you tell him not to come back Monday, how could you even possibly make some decision over the weekend if you already tell him not to come back on Monday? So we'll see. But let me try to finish this up. No, he decided, then he said he'll think about it over the weekend when all of Diddy's attorneys started popping up like popcorn, pulling up their case law from Westlaw, and was like, Judge, you don't have discretion for this. And this, I know you're saying it's not racially biased. This whole darn case has been racially biased. You can't tell me it's not racially biased when you have 9 preemptory challenges and 7 are the black people. They do their hearing to try to challenge the government trying to get rid of all black people, and it's still based on my husband had a conviction, my brother had a conviction, I had a run-in with the law, and it was inconsistent on to where they stood with law enforcement, like they found reasons to dismiss them. So they're saying from the beginning of the investigation, which is what we're going through now, all the way throughout even this whole trial, it has been racial bias. What I believe, and I've said this before, is I believe when they did all them raids, they didn't get everything they thought they were going to get. Because we heard about all of these. You had that Courtney Burgess fella. We don't see him no more. He even went in front of the grand jury, but they ain't got him up there on that stand. He sat up there and said that somebody, that Kim Porter gave him her manuscripts, and he also had a videotape and had an attorney, Ariel Mitchell, get on some platform and say basically she's seen, I think, a still shot of it. And whoever this celebrity is, that I would suggest they do a catch and kill and because you don't want that out type thing. So he was alleging on videotapes they found Diddy with minors and all type of stuff. So there were a lot of people that were just saying things in the media. And I think when the government went in thinking they're gonna find validation to some of this stuff, and they did the raids of all these houses, didn't find what they thought they were gonna find. In fact, the tapes that they found of the actual freak offs were on Cassie's devices in her house. So she consented to two devices for them to basically look at the government. One of the devices was working. One of them had been rebooted, so they had to take it straight up off of the server. And then they had a third one that they had to get a search warrant because when you opened it, it said Frank Black. So they knew that was Diddy's alias. So they didn't even try. She couldn't give consent because 9 times out of 10, it was Diddy's laptop. So all of that stuff came from stuff they found on her. It wasn't in his house. So that's what I think, is that they were looking at these lawsuits and people talking about they put baby oil on me and I just passed out and I woke up and Diddy was on top of me and somebody else was behind me and this other celebrity was to the left and all of that. And I think that's what they thought they were going to find, and they did. Because look at all these lawsuits and you don't have none of these people that are really testifying. So you have all these, like their attorneys were showing up the first week of trial. So, and what they're saying in this letter is that the government seen that a lot of these people were not credible. So that's supposed to be why they didn't testify. It's Mimi said, yeah, some of these folks reporting straight from the courthouse I see are divided. They either for the government or for the defense. I'm like, are these folks? That's what I just said before. I was like, you almost think you're in 2 different trials. Oh, it was a horrible day for Diddy. Oh, he is hit. It's a wrap. It's over for him. He's doing life without the possibility of parole. Like, you hear all of this reporting and you're like, I got the transcript and nothing of what you saying happened in this court. That's why I started getting the transcript, because it was so different, like starkly different from how people were reporting. You had a couple of people that were like swinging for Diddy, but then a lot of the reporters, the only person I can say seemed more down the middle would be Armand. Like, he seemed more down the middle because he'll say, I think the government got it today. And he'll say like he don't like Diddy because of the Cassie video or however he said it. But if the government got whooped up, he'll say, I don't know that. Then with Jane, he was tired of Jane too. You had the whole balcony situation. Like, it was just certain people. It's just certain people that took the stand that you just can't deny, like their inconsistencies or testimony that just wasn't matching. Like, the math wasn't mathing. But it amazes me how you get some content creators that are somehow able to sway that like it's a win. But I went through that with Tory Lanez. With the people that were Tory Lanez, when I was like, girl, that was damning. What are you talking about? Like, with a couple of people there that were just so pro Tory Lanez. You think so? Yes, absolutely. You really think that that was good for him? And they would hear what they want to hear. When they like somebody, they hear what they want to hear, apparently. Kia Elder said, I stopped watching that mess. You can tell who likes Diddy and who does not. A big headache. JC Talks Trial said, they lying. I've need to court at least 2 times a week and they come out of the courtroom lying. It's sad. Yeah, I don't know. That's why I go get the transcripts, or certain people that I think are decent. And it ain't even necessarily, I get it. Everybody is not a lawyer. So they're doing it from their assessment, which will, when you really look at it, that's why I said that jury instructions are very important on what the facts to prove that they have to prove. But when you look at it, it is a jury of your peers that is the fact finder. So they're the ones that make the ultimate decision. So to see other people's perspectives is very, very interesting, but it also shows when someone don't like you. That's why voir dire is important, because there are some people that just hate anybody that put their hands on somebody, put their hands on a woman, because maybe they went through it. Maybe they watched their dad do it to their mom, and they can say, I'm not biased, but then in the back of their head, they're like, oh, if I could fry this dude, I'm frying him. Like, it's a projection, because maybe they couldn't get the person that did it to them or whatever. And you, as an attorney, that's why you hire consultants, because you want to weed that out. Because a lot people care about what strangers think of them, like just like social media. So they don't want to say, no, I can't be biased at all. I can't be unbiased when it comes to this. They are going to say they can't be biased. A lot of them say it. Yeah, I got an opinion. My mother was beat up, but I still can be unbiased. And you got to like focus on that person and try to find some way on whether you really want that person on your jury. And it is actually a science to it. That's why you hire consultants. So yeah. So I'm going to show you that in a minute, educator. Let me get through this. Prosecutors, this is the next bullet. Prosecutors use the grand jury to help unscrupulous plaintiffs obtain publicity for wildly false claims. After Mr. Combs' arrest, while continuing its investigation, the government publicly paraded witnesses into the grand jury to feed nonsensical media narratives that they knew were false. This created an atmosphere of legitimacy surrounding the many false and wild claims about Mr. Combs and the media circus created by unscrupulous plaintiffs' lawyers who have encouraged people to file bogus lawsuits against Mr. Combs. That's what I was talking about with the Courtney Burgess situation. There was a camera out there when he was with his lawyer, and they were coming out of the grand jury or they were called to go into the grand jury. So of course we all like, oh, they called him. Maybe they actually have something to corroborate what he's saying. And then he went into the grand jury, then you didn't hear about this man no more. Like, we don't hear about Courtney anymore. Prosecutors attempted to introduce unreliable, decades-old, highly inflammatory allegations and use allegations about additional, quote, victims who never testified to obtain search warrants and seek detention. The government attempted to prop up its case with old, unreliable, and highly prejudicial and inflammatory Rule 404B evidence, much of which the court correctly and fortunately excluded, and granting the defense's motion to limine. So they were trying to do prior bad acts, is what they were trying to enter in, so that they can bolster. We just can't stand this guy because he just is a menace to society. So he may not have done that, but he did something. So let's maybe split the baby and give him something. Like that type of shenanigans. It sounds like they're saying may have been the purpose, allegedly. And although the court denied the motion to exclude the testimony of one alleged victim, another girlfriend who had no interaction with any of Mr. Combs' employees or the alleged RICO enterprise, that individual apparently has decided not to testify. Likewise, the government spent over a year claiming that Mr. Combs' former girlfriend Gina was a victim and used that allegation to support arguments for bail and to obtain warrants, and presumably in the grand jury, even though blank and the government did not call her as a witness. Despite including her in the indictment, the government has not elicited any evidence at trial that could possibly support the conclusion that she is a victim. Prosecutors have engaged in other misconduct during trial. We recognize that the court has denied our two mistrial motions, but as the court is aware, we believe the government asked inflammatory and highly prejudicial questions of Inspector Jimenez to try to suggest Mr. Combs had somehow orchestrated the destruction of fingerprints evidence in 2012 and then presented testimony from Cassie Ventura and Brianna Bongelin that it knew or should have known was materially false. The government's history of these extremely aggressive tactics in this case is critical context against which its attempt to remove the juror must be evaluated. In this case, the prosecutors have repeatedly flouted their office's self-proclaimed tradition of doing the right thing the right way for the right reason. Their pretextual motion to dismiss juror blank is just one more attempt to gain an unfair advantage at the expense of Mr. Combs' right to a fair trial, which is all we ask this court to preserve. For the foregoing reasons, the court should allow the juror to remain on the jury. If the court truly believes his statement raised serious concerns about his ability to follow instructions, which we respectfully submit would be an unfair and unsupported conclusion, based on what were at worst imprecise answers to the court questions, then the fairness, and then it's redacted. If the court dismisses juror, then it's redacted. The unfair prejudice from replacing him with the first alternate at this late stage of the proceeding warrants a mistrial. So they said either let him stay or give us a mistrial. Okay, let me see. Someone asked about the perjury. There was something that was filed. Let me see if I can find it. I keep saying I'm gonna clean off my laptop, but I don't. I know I put it in my membership. Here you go, I think. No, that's not it. All right, hold on one second. Let me try to pull it out. Hold on one second. Let me just pull it down. Make sure you guys hit that like button. We are going to, this was the proposed cure that the defense is asking for based on the perjured testimony, that the judge will include as a jury instruction as a quote curative instruction. Because I was wondering how you gonna cure somebody just looking like they straight up lied, but let's see. I know the government, these prosecutors probably ain't had to do this much work since they started practicing on one case. They like can't stop, won't stop. Let me see. So they asked for a NAPU instruction. Let me see. All right, let me pull this up right quick. So this was the proposed instruction by the defense. So they say, the defense respectfully submits this letter in response to the court's invitation to propose an APU instruction to address witness Brianna Bongolan's perjury. We requested the court read the following to the jury at some point on Friday. So it was supposed to be like read to them or whatever. I don't know if the judge did it or proposed to do it. I don't know. So they wanted them to read: the government elicited materially false testimony from Brianna Bongolan about the alleged balcony incident. Specifically, when she testified that she received injuries to her legs, back, and neck at the same time, and that these injuries were all caused by Mr. Combs on the same day. She took photographs of her leg injury September 26th. This was not true. So that's what they want to be read to the jury, probably do an instruction as well. And I wasn't there, so I don't know if that was read or not, but that's what they were requesting. You said they thought he was going to plea out. Well, they definitely thought wrong. He was you know what? Honestly, I started believing that it wasn't going to be everything that people thought it was. Okay. I thought it was, he was way too adamant. Like, a lot of people will say it's all gonna come out, I'm innocent, and they'll give the same kind of blur, and that don't really move me. But when you like the specifics of it, that's what made me think, like, okay, all of this stuff about this lace baby oil and these minors and all this stuff, I don't think that's gonna come out. And then when the indictment came out, I said, well, maybe they gonna supersede it. And then they superseded, just like explaining, I think, on one, and then they added Jane Doe, I think, on the second superseding indictment. But it was never anything that would like expand it to those type of allegations that were wild in the media. So yeah. So MA said, I think the judge is fair. You know what? I thought in the beginning he was fair. I think his motion and limine ruling seemed to be fair based on what they said. But I think, and maybe this is me personally, because I've had that happen to me before, where I have vigorously argued. It was a case that I had, and I was arguing a motion to exclude something. This was years ago. I was arguing a motion, and the judge was like, all right, your motion's granted. The prosecutor, this was state court though, but the prosecutor literally started sniffling, like, judge, could you at least just let us, because it would have like smashed their case, So, judge, could you at least just let us, respond to what counsel was saying? You wrote, like, what are you talking about? You wrote your response. You just wasn't prepared for my oral argument. So she was dang near crying. Like, her voice was shaky, and I ain't saying it was just me. And she was like way more seasoned than me at that point. And so the judge was like, are you crying? Like, the judge asked her that, and she was like, no, I just got allergies. She picked up a little tissue. Like, I got allergies. She's like, judge, I just believe that we need more time so we can respond. This is very critical to our case. We got victims. We got victims here who their family, is here to support them, and da da da. She went through her whole spiel, and then the judge was like, all right, well, I'll take it under advisement. I was like, what? Yeah, like, what are we doing? And I'm not saying, like, there was a time of which I can appreciate judges that realize they made a mistake, in their ruling, and they're willing to overturn themselves. And I've seen Judge Submaranian do that as well on this case, which made me say, okay, he's fair. Like, you got to respect when you say I'm wrong, then, maybe I need to walk it back. But when you got it where you telling them you ain't really got no argument, and you trying to go back up to the prosecutor's office with 20 other attorneys so you can try to come up with an argument to go against me, little old me, that's probably like 2 years in the practice. Like, that's probably what made her more mad. She looked at my bar card, because you can tell by the numbers how long somebody been practicing. Because, she probably was like, I ain't gonna let this doggone 7 beat me on something like this, because that is how we be thinking. Like, oh, you just came out. Okay, let me just. And I always said I would never be like that, because I knew people did that to me. But now I find myself doing that with some of the motions I'll get. I'm like, Oh, okay. They've been out for about a year. All right. We gonna be a little, not as harsh on them. But yeah, so it does happen, of which sometimes it seems like if you bang the table enough, the judge will just be like, you know what? All right. That's how I feel sometimes. So I can appreciate the defense doing this and being like, no, we're about to make such a big record that if we have to appeal this, we coming back. You about to see our face again because we are fighting every nook and cranny, which is very cool to see them have an appellate attorney on there who this is their specialty. So they know what needs to be objected to, how to preserve a record. Because what happens is if you don't object to objection, hearsay, objection as to inconsistent, whatever your objections are. If you don't object, then you can't debate it on the Court of Appeals. All the Court of Appeals does is they look at your record from the trial court. So if you don't, so objections are very, very important. So when people are like, they going with another sidebar or whatever, it's because you got to preserve the record. You have to preserve the record because if you don't preserve the record, it can be waived. Like you're basically waiving it, waiving any objection to that issue. So to have an appellate person on there is like pretty dope that they're sitting there like this is what they do. Their job when you're an appellate attorney is you go through trial transcripts, you go through the motion hearing transcripts, you go through everything, you try to find reasons to appeal that the decision that was made was whatever the standard is and so did not meet the standard or it was abuse of discretion or whatever that standard is and the judge abuses discretion or it was palpable error or it was plain error, harmful error, whatever the standard is, and you have to, or they review it de novo, which is basically they review it as if they don't have to give the court discretion at all. They can just read the arguments and be like, no, he or she just ruled wrong. So basically, a lot of this that people don't know, and they're like, they always crying and fight. That's what they're supposed to do because you have to preserve the record or you lose it. So if you have to appeal, you want to be able to hit them with everything you can that you may be able to get. Um, you may be able to get uh your case basically a dismissal or a new trial. So that's your point. So when people are saying the defense is doing what they're supposed to do, that's what they're paid to do. So yeah. So you said Cassie didn't say she saw it. She said in the paperwork she was present. So I went over the actual lawsuit. The lawsuit she filed is different. And we went over that as well. So just for you, before I get off of here, I'm gonna pull that little lawsuit back up. And then first of all, they that with the balcony incident, Cassie said it was in a hotel. Brianna said it was in Cassie's apartment. In the text message Cassie sent to KK, she basically said that she sent to KK, she basically said that I just learned as if someone told her about it. Cassie also said it was in a different month, I think, than Brianna as well. So there was definitely inconsistencies that was going on between both of them when it comes to that specific incident. But let me pull this up. Don't take my word for it. You know how I am. Where's your authority? Y'all know me. So let's see, Cassie. Let's see. Cassie B. Puffy. Let's do this. Yeah, the issue, you're right, Tracy. The issue was that she, I'm going to go over this one more time. Let me pull this up first. Let me take page 19. I ain't know the page, okay? So, let's, uh See, a lot of this with this, when I read it again, I was like, this is kind of where the government like really got their stuff from her lawsuit. So let's check this out. So, like at paragraph 97 in her lawsuit, it has he even would present her with lavish gifts prior to or in the middle of the FOs, seemingly acknowledging the ways in which these forced actual encounters constituted work for Miss Ventura and that he needed to compensate her for this work. At one point, he had given her so many designer bracelets for FOs and immediately following his brutal beatings that she felt that she was shackled by his presence. Frequently, her anxiety before FOs would become so great that she would become physically ill, sometimes to the point of vomiting. While kneeling over the toilet, Mr. Combs would shame her into performing for him, eventually forcing her to get up and proceed with the encounter. She knew firsthand that telling Mr. Combs that she did not want to engage in FOs was met with anger and violence. We ain't get that. She said in her mind she didn't want to do it. She never really told him. In addition, any suggestion that Miss Ventura will refuse the FO or otherwise report Mr. Combs' abuse was met with ultimatums by Mr. Combs, who would say that Miss Ventura could not go to the police because she had a lot to lose. But then we heard testimony that the ex best friend, the police came to the house and he was like, she didn't give the police the name. Diddy wasn't even there. She didn't get the police the name. Then we heard a story about them being someplace on the island or whatever when they went out, and the police I think was called down there at that time too, and she didn't give a name. But this is what was in the lawsuit. And I think that's why when he says that it's not true, some of this stuff based on his testimony really does not seem like it was true. But what happened is the leak came out of the video, which nobody knows who gave it to CNN, and everybody was like, "Oh, I thought you said you lied." None of it happened because she mentioned that altercation in here. So what happened is now people believed everything in the lawsuit because of that one, him basically coming out and saying it's all a lie instead of saying a lot of this is made up and it's not true, and making it seem like there's room for some of it to be true. Maybe not, I can't say all of it ain't true. I can't say all of it is true, but I can't say all of it ain't true. He didn't do that. He just said it's all a lie. People lying on me. It was the way he said it. And you can tell he said it out of just being angry, and it wasn't no PR, wasn't nobody wording it correctly, and he just came out and then he had to eat his words because somehow when he said that, all of a sudden this video leaks, which makes it look like everything Cassie said was true, and that's why he paid her. So this is the balcony incident. Around August 2015, for example, in the middle of a surprise party dinner for Miss Ventura's 29th birthday, Mr. Combs insisted that Miss Ventura leave the party and go to a hotel for an FO. When she expressed that she did not want to go, Mr. Combs had Miss Ventura cornered by his security staff in order to force her to leave with him. After this FO, Mr. Combs and Miss Ventura went back to the hotel room that Miss Ventura was staying in, where some of Miss Ventura's friends were already hanging out. Mr. Combs was severely intoxicated and at one point during the night picked up one of Miss Ventura's friends like a child and dangled the friend over the balcony of the 17th floor hotel suite. Miss Ventura and her friends were scared by Mr. Combs' erratic behavior, but Miss Ventura was heavily sedated because of the drugs she took to participate in the FO and therefore was unable to respond to Mr. Combs' terrifying behavior. This is what she said in her lawsuit. Then she got on the stand and I think she said, I think it was Brianna Bongelin said she didn't see her be dangled off of the balcony, and it didn't happen at a hotel. It was at Cassie's apartment. She said when she got thrown on the furniture, she heard Cassie's voice. So they caught her up on that. Didn't you say you saw it, or didn't you say you was there, or whatever they were trying to do? And she was like, I stand by what I said. Yeah, if Diddy would have waited to settle with Cassie, then I don't think he would be in prison. He would be in jail right now and on trial. But that's just me. Because by this time you would have had discovery and everything else that was going on. But he may have said he can't do discovery because he knew it was a criminal investigation. So it would have been a catch-22. But once it got filed, there was no reason for him to settle in 24 hours. The point of paying someone most of the time is so it doesn't get out. And it's not because you're saying you did it. It's because of look at this train wreck that happened because she filed this. And some of this stuff is not mathing. The math ain't mathing with what happened on that stand, with what she testified to. And what some of the evidence showed, it just was not mathing. Now you have 50 lawsuits. You had an attorney who did a 1-800 number for freaking Diddy. Said they had over 3,000 calls. You got Don Richard, who was trying to just work with Diddy not too long ago to restart this group, Dirty Money, that filed a lawsuit. So it did. It met, and everybody's like, Cassie gave me my courage. Cassie ain't thinking about y'all. She got her 20 million. Then she got 10 million for the hotel. She not thinking about y'all. I agree with that, Judon. He should have paid her the 30 for the book. That's it. I agree with that. But that's the point of it. Once it was filed, there was no purpose of him settling like he did. The only thing is people automatically believe he settled because he did everything. That's what people believe. So now when you get indicted, people in the public who is your jury pool, they think you did it based on you settled. You lied about the video. We saw the video. Almost everybody saw that video. I don't think they had any juror that said, no, I ain't see that. Everybody saw that video. So what they're alleging is from the beginning, this was just a way to take him down as a successful black man. That's what they're saying. And we can't say that it's too far-fetched. Yeah, all settlements say they don't admit it. Like, all of them say we by no means admit any of the allegations. Every single, I don't care if it's just a dog bite and you got the bite on your leg and they settle. They're still going to put in there, we do not admit that we did anything wrong or that our client did anything wrong. This is not an admission. In fact, we vigorously deny that we did anything. That's what's going to be in that settlement. They're going to keep it confidential. For celebrities, they're probably going to tell you can't talk bad about them, no disparaging remarks. If you tell, unless the courts tell you, the courts are the only one that can tell you to say how much money you got or anything that's in this document. The court of law can make you, regardless to NDA. That don't matter to the court. If they call you to court, you got to say what need to be said. If they ask you the questions, and you got to tell the truth. So that's how we know about the 20 million. If she didn't get on the stand, we wouldn't know she got 20 million. People were speculating she got more than the 30 million. They were like, you should have went on ahead and settled. I heard she got 100 million. I mean, I ain't saying 20 million ain't too ain't too shabby now. But it's definitely a difference between 20 million and 100 million. I've done employment settlements, get that, but credibility is shot. Yeah. People naturally believe if you settle, then it's because you did something. But they don't know, which people are probably going to learn now because more people are so into the law that I see more of, is that they do cost benefit analysis. Diddy paid probably, we know he paid millions for this dream team. So in his mind, I guess if he paid her the 20 million, maybe all this stuff, because it's off the docket now. Like, I think it's sealed, the lawsuit with Cassie. But those of us that have it already, I mean, I guess we just have it. So yeah. So that was that on the balcony incident. Y'all got any more questions before I get on off of here? Thank you guys so much for hanging out with your girl on Father's Day. I appreciate it. You said Puffy just turned into Wreck from the 5 Heartbeats. That's from B1 speech. I don't get it. You're going to have to help me. Lindell. So yeah, so the metadata, the issue that happened with the metadata, Brianna did not say it was around this time. I'm not really sure, but it was September, whatever. Like she gave a specific date. And how she gave that specific date was she said on the same day, she said all of this balcony incident happened early in the morning. So we talking about 2, 3 in the morning. Later on that day at about 9:45 a.m., she said she took pictures. She went in the shower. She noticed she had a big bruise behind her leg. And so she took pictures of it. So when she took the pictures, she testified the pictures were taken on the same day of the incident, the exact same day. So the defense looked at the metadata to see when she took this picture. She took the pictures in September, I think it was 26. However, the defense had receipts and proof of his whereabouts, and Cassie wasn't even with her. So obviously you ain't heard Cassie's voice. And it was September 26th. As you see from this lawsuit, Cassie said it was in August. So let's just assume she got it wrong and it was in August, like Cassie said. The problem is you're saying you were injured, and bruises a month later is not going to coincide. And a neck brace that a couple of days later or something, a couple of weeks later, I think she went to a chiropractor and she had a neck break. All of this, if it was not in August, would have been so far removed from August that you shouldn't even had all these contraptions on. And apparently she even went to a couple of the bad boy concerts or something, and she didn't have the neck breakers on either. So that came out. So that was that for September. Let's just assume it did happen in September. The problem is, so that would mean Cassie's rendition is wrong. It was not at no hotel, it was at her apartment. If it was in September, Cassie can't say she saw anything because she was not there. She was with Diddy. So that makes it a problem. And then Brianna couldn't have heard her voice because she couldn't have been there to hear her voice because she was with Diddy and they had the receipts. So this is what I'm saying, how conflicting the testimony is when it comes to the balcony. Now, I don't know if they asked Cassie about Brianna calling her and telling her you got it wrong about what happened in the hotel. I mean, what happened when I got dangled over the balcony. It wasn't in a hotel. I don't know if Cassie testified to that, but we know Brianna testified early on because the government was getting ahead of it. They were like, did you call Cassie when you read her lawsuit? Yeah. And why did you call her? Because she had some of the facts wrong. What facts did she have wrong? It didn't happen in a hotel. It was in her apartment, in Cassie's apartment. And it was the ex-girlfriend that was there. It wasn't the friends, Tiffany and whoever else that she alleged that was in that apartment at that time partying for her birthday. So she's saying it didn't happen that way. So how can the jury, what can the jury do with that? Who do you believe? What can the jury really do with that? If it was in August, your pictures couldn't be injuries from Diddy. And then if it was in September, Diddy wasn't there and you was with him, so you couldn't have heard nothing. So that's what I'm saying. Like, it's just very conflicting. But then the government said something about right. That's what it appears. So the government also well, no, I'm sorry. The court actually said, well, everyone was on drugs, like almost made an excuse for the inconsistently from like to help the government out. Almost was like, everyone was on drugs at that time. She was doing a lot of drugs, so almost like maybe her mind and her time and dates she wouldn't remember. Like, so I think she don't recall because she already testified she was doing heavy drugs. So that was like a statement I think that the court made. But if that's the case, should none of these jokers be testifying because everybody was high? So that should be an excuse for Diddy. He don't remember none of this. All this stuff was made up. That could be an excuse for Jane. She was high, higher than a kite too. Cassie stayed high. She even was high. She was high up until 2023 when she went and got sober. I guess she went and got treatment in 2023. So she even got high outside of Diddy. She testified with her friends. That's how the best friend got hit with the hanger, allegedly, was over drugs. But the best friend testified it was over something totally different. But I think Cassie it was because Diddy came in and saw drugs on the table. And then the best friend, the ex-best friend, was threatening to sue Cassie and Diddy. So Diddy paid her $30,000 because he buffed her in the back of the neck with a hanger. Saying. I'm not putting Banner's lawsuit on this. What does that matter what her lawsuit says? September 26th. That's the date of the picture. So what are you saying? I think her lawsuit is is it in California? I'm not paying for her lawsuit. I definitely ain't after hearing her testimony. And another thing, since we talking about Brianna, she also says she fired her attorney because her attorney lied. This is Blackburn in the lawsuit, and then asked about the actual abuse or actual molestation or something, and then asked for $10 million. So that's supposed to be why she fired him. So then Westmoreland asked her, well, you didn't even correct that in your lawsuit. You still was saying you were molested or touched or something by him in the lawsuit, and you asked for $10 million again. So why exactly did you fire your attorney? And she really didn't have anything to say. And she said she read the lawsuit. So she knows her attorney had to read the lawsuit. I don't know if she applied to it or signed her name, but she actually did say she read the lawsuit. She said with Blackburn, she never read the demand letters. And Blackburn kind of be, he be fluffing it up a little bit sometimes, it appears. On or about is legal phrasing that you use at the beginning. You can know the exact date of a car accident off of a police report, and you still put on or about February 13th, 2025. Like, that's what you do. That don't even matter in her lawsuit, though, because on the stand under oath, where she swore to tell the truth and nothing but the truth, she said, I took this picture on September 26th. She said, I took this picture, strike that. I took this picture on the same day that this incident happened. They looked at the metadata, and the metadata said September 26th. So the on or about don't even matter. So September 26th, and Diddy wasn't there. So yes, and if the judge says I'm going to entertain an instruction that basically she misrepresented or she lied or whatever, then the judge knows that the math wasn't mathing either. That's it. Yeah, everybody was high. That's what it sounded like. Everybody was getting it in with what they should have did was got him on some of that. When them police came to the young lady's house with the hanger incident, Cassie refused to give her name. That was a time he could have went to jail. It's another time of which they say the police came out. It'd been another time he could have went to jail. The thing was, anybody in domestic violence relationships, they're going to leave when they get ready. Nothing you can really do about it. They're going to leave when they're ready. It's Mimi said, oh, wow, I thought the judge approved that language and rules. She didn't lie. No, the judge just denied the mistrial. The judge denied the motion for a mistrial. And then what happened is they said, well, we can instruct the juror. I will entertain. I don't think he said it for sure. I don't know. But they wanted the jurors to hear about Brianna and how she misrepresented and said some things that were not true. So something can't be something ain't right. Like I said, if she got the date wrong, then them bruises, he didn't injure you. And that's kind of what you're suing for too. So if she got the date wrong, that means that you may have not been injured. If we go with Cassie's rendition, of which I believe she stood by what she said. So one of the escorts who was with Jane Doe did an interview with Tasha K and said Jane Doe was a willing participant. Was that on her app? Because I know our mom was he's interviewing. I'm gonna look at that probably when I get off of here. Armand is interviewing somebody as well. But I'm gonna be on tomorrow. Just me. You late. But you gotta pay those bills. Thank you for coming on. I appreciate that. Yeah, she gonna have a tough time with that one. Yeah, he settled because he didn't want this stuff out here. But when I'm looking at her lawsuit, it's not all matching, and it was too late. Like after it got out in the public, it was too late. It wasn't no point. What was the point of even like settling at that point? You said it's on her app. Okay. His name is Rico. How interesting. I think his name did come up, right? During the trial. I think a Rico came up for Jane. You just finished Armand. Was it good, Marset? What you think? Should I stay up a little bit longer to watch it? Hey, cousin E, good to see you. But I'll get on there and try. Hopefully, we don't have issues with the thread tomorrow. But I'll get on here and put in some hours. Put in my Diddy hours tomorrow. Al Reynolds interviewed. Y'all moving too fast. Queen Brielle said Al Reynolds interviewed Rico last week. Oh, okay. So now all the ex workers want to come out. I saw the one with the Punisher. He still said, I don't understand why they called me because I live in New York. I did all my dirt in New York. And he was he was like, and I apologize if Cassie felt like she said, but she enjoyed herself. So I don't even know. I don't even know what we talking about here. I kept asking the he said, I still don't get how the court plans on using my testimony. He said he still don't understand. And he was like, he said that when the government first approached him, they kept asking him, does he want an attorney? Does he want an attorney? Then he said he seen why when he came. He said he didn't trust him at first. He was like, "Why am I gonna get the government's attorney?" So he went to try to call around and get his own attorney, and people was like, "Oh, this high profile case, I'm gonna need a $20,000 retainer." He was like, "Hello, government, is that attorney still available?" So he ended up getting an attorney. They sat down, and he was saying, he said they asked him to tell his story. He said, "You better tell the truth, or there's consequences to your lying." And so he told his truth. And then he said, then they had all the text messages and they handed them to him. And so he was like, but I had already told the truth, but they already basically knew everything because they had all he said, he's like, how did they even get all of these? But they had the text messages and stuff from his phone. Ooh, gotta wait till my daughter go to sleep. Can't put that on the screen. Did he meet with him 27 times? I don't think so. He said basically, I guess they were satisfied with his testimony because he didn't meet as many times as the other individuals did. Like it may have been the least amount that I've heard. And he also said that they had him come back like the Saturday before he was going to testify, and they did cross examination. They practiced cross examination. So he felt like they were more they didn't prepare him really for what happened with the defense because he said the defense was not mean, like coming at him, like how they heard other people. He said the defense was basically almost validating a lot of the stuff. Like all they wanted to get from him was, well, did you think it was consensual? Did she ever say no? Did she ever say she wanted to leave? Did she ever tell you she was unhappy? Did she ever look like she was in distress? Did she ever look like she was there against her will? Like those type of questions. They weren't really trying to like badger him. He wasn't a person to badger. He was a worker. So he was like, it was actually pretty cordial and softer than what he thought it was. He felt like they validated him and his testimony more than anything. So he didn't think that, but he said they did practice as they've done. And as you know, we all do with our clients is you practice, you get someone who probably is not the one doing your direct examination to cross-examine them so they can be prepared and not do like what Jane did, even though she was prepped. What Jane did was she was boohooing and crying on direct, and she was like couldn't hold it together. And then on cross, she was just like tough. I mean, like she had a bunch of courage. She was getting smart. Her mouth was slick. She was like, Don't ask me that. Why are you asking me that? Why are you saying, why did you say the gender of my child? Just say my child. Like she was going, like it was a whole different person. Like when she got on there, you need to be the same all the way around so you don't look like how she was looking, where you just kind of like, oh, okay, so you crying. That make you look like a little actress that you could just cry at the drop of a dime. And then at the end, when she hugged, I guess the prosecutor, and then you hugged the defense that just tore you up. And everybody, they said the defense table, the people that were in there were looking like stunned. Like Shapiro or whoever crossed her. Who was that who crossed her? Garagos, I think. Garagos, they said she was just sitting there like when she hugged her. And then it was like, they said a couple of the other lawyers was like, because I was like, somebody asked me, have you ever heard of that? I was like, never. And it was in front of the jury. Like, what is that? You may be excused, and you go hug the prosecutor, and you go hug the defense. Huh? Elise said, but I heard Tina gave her like the shoulder when Jane leaned over trying to give. I definitely would have, because that's not a good look. If I was Diddy, I would cancel that Jane contract. Jane said in 1 month she made 50K. Trey, I think once she got off that stand, he told his attorneys to go call his accountant when they leave and cease all payments. Probably told the attorney that he was paying for, send me your final invoice, because I know it sounds crazy that he's still paying for it, but if she's going to testify against him, maybe he shouldn't have been rocking that boat right then. But as soon as she got off that stand, they said Diddy writing a bunch of sticky notes. I'd have been like pulling out my sticky note. Stop. 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 That's, they said that's all he. Shoot. It's Mimi said when Jane Doe heard about the message Paul received to convince her to do the F-file, her entire disposition changed. Yeah, he was right there. He was at the defense table. Where you think Diddy was? He, it's his case, right? Right? I mean, not Ray, but that was Daniel that said that. Sorry, Ray Ray. Ray Ray said, yes, Jane wants to remain his number one, even though it's by default. If Diddy mess with her then again, and that's on him, you get what you get. Listen. Stop. Just me say, yeah, when they read that to her about Paul, she became hard and defensive. Listen, stop. Somebody needs to get blocked, huh? Let's see. Why are you arguing something that's a moot point? This already has been litigated in the court. And that's that. And I said the text message. The text message said, I just heard something wild. Why blah 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 blah. Diddy came and he held her over the banister. The point of the text message was they were saying that the government's trying to use it to corroborate her testimony. However, Diddy and them is using it to say it wasn't anything Cassie can testify to, because she's basically saying she heard it. That means you're not there. You don't have to say this is something that I heard if you were there. I'm just saying the stories don't match. It's a moot point. The courts, I don't even know why we still arguing about Brianna. I don't even understand. I think it is what it is. Whoever believes, all I'm saying is it ain't happened on the days they saying it happened. That if it happened, and you got to prove it happened, and they haven't been able to prove that. That's all. That's it. Good God, relax. The resident therapist said that chick was showing several parts of instability, disassociation, and cognitive dissonance, and it's real. Okay, the resident therapist, you better talk your talk. Can you tell us what's wrong with Diddy? Nah, he's probably gonna have an expert to come up that's gonna explain, because I need to get in his head at this point, because what? She is talking her talk. I can appreciate your professional expertise. Kim C said, "Thank you, Pam, for your thorough explanation and your comedian thoughts to help with understanding." Thank you, Kim C, for the kind words. I appreciate it. Said I can't afford the store. You're very smart. Very, very smart. Listen, everyone can think what they want to think. Like, even though they can't prove it, I believe. Even though we showed there was evidence that she's a lie, that she perjured herself, I believe that this happened. You're entitled to that. But it's not what you believe, it's what you can prove. So there is no evidence at this point that really proves that this happened. That's what I'm saying. That's pretty much what has come out, of which they're trying to do a curative instruction related to it. I can tell you, if this goes to the Court of Appeals, there's going to be an issue with those two testimonies. And for the judge to say, well, everybody was, well, that she was doing a lot of drugs, so she probably just got confused, or her memory is, yes, that could be an excuse, but that's not evidence. That's all. That's it. Lindell, I told you, social media is, and media period, is nothing but organized ignorance. Because everybody just believe it. You can say, because I don't like him, and just be honest about it. But to try to argue with me about things that haven't been proven in court, and I'm spending money on transcripts and watching it every day and getting inside information from people that's in the courtroom, like, it was an issue. There's an issue of which the court denied a mistrial. And then made the comment and said, this is the court. Can't you just take this pair? I have to admit, you did have your Perry Mason moment. So basically acknowledge that you got caught. And the judge said it. You got caught. You're saying it happened on this day, but you weren't, they're able to show almost every step of the way where Diddy was. It wasn't just that one day. It couldn't have been in that whole week, basically, or 3-4 days whenever they was checked into the hotel. They show what he ate at that time, what he was eating. Then they show where he was to perform, like, immediately after that in the morning time. It just was, the math was not mathing. If you were on the jury, would you convict on trafficking? Me, no. I feel like a gray area as far as whether or not it was commercial X with his girlfriends. If it were me, I wouldn't do the RICO, and I wouldn't do the trafficking. Now, the prostitution for me is up in the air. I'm going to be honest. Prostitution, it is what it is. You pay for X. I just think it should be more people next to him, if that's the case. But everybody got immunity. But I could totally see, like, the prostitution. But that's the lesser of the charges. Like, they threw that in for good measure, because RICO will take you out of here and take all of your assets. So that's the big one. And Dale said we were all brainwashed by social media before the actual evidence. It's time to wake up. With yeah, we all heard stuff where when I got into, you can probably look at my old videos and I was probably on his neck too. I mean, it's like I was like, they're saying, oh, they at the grand jury. Like everything they're saying, how it affected the media, I can admit I was that one of those people. Then what made me start changing the tide, aside from me consistently saying, regardless of whether we like him or not, he's innocent until proven guilty beyond a reasonable doubt, and consistently drilling that in everyone's head, is when I saw the indictment and it had nothing to do with what was out in the media. I'm like, okay, so where the baby oil being laced? Where's all these celebrities on here? What are we doing here? You gotta reach. It was reaching too far. Like they can't deny that his businesses are legit. Like the defense said, I said that you can't deny that. They're trying to, I guess, say because using with the enterprise, you have to show basically your enterprise is created through crimes. That's pretty much what it is. Like in simple terms, it's like your enterprise. When you have car washes and you were a drug dealer and you were able to purchase the car wash from the proceeds from the drugs. Then when you have a conspiracy, you have to have an agreement. So they're alleging conspiracies with people that are, I guess, unindicted co-conspirators with them, which can have, you can ask for certain inferences based on them not calling certain people. So I just want to see how this goes. That's all. Yeah, Dev said Diddy was guilty before he ever went to court, all because of how the media painted the picture to control how he. Yes. And I think, again, for his friends, I still feel like it's foul that they did not check on his kids. I could see not telling him don't call you because you ain't trying to get your phone tapped. And that's type of stuff gets you involved. Depending on how Diddy might say something crazy, really be thinking about, yeah, I just saw a rock when I was out on the yard. They'd be like, we're doing a warrant. He just talked to somebody about a rock. There's probable cause to believe there's drugs inside. Because they already said there was some type of information about potential contraband or something like that. So you have to be careful on the phone because they'll say anything is probable cause based on their interpretation of things. They can say you get on there talking about, yeah, I'm cutting down trees, and they'll say, oh, they talking about weed. And you really are a person that a lumberjack that cut down trees. So you have to be careful talking on the phone. And you don't want the government to know who you are the closest to, because they may try to get you to talk to you and pull you into things you ain't trying to be in. So I can totally see that if they're distancing themselves from him for that. But at minimum, you can call his kids and be like, hey, y'all all right? You need anything? Did you eat today? How are you feeling? Do you need a therapist? You lost your mama, now your daddy's fighting for his life. Is there something that I can do to help you? Because them kids ain't got nothing to do with it. That part, for all the people that were supposed to be his friends and family or whatever that didn't do that, they are whack. They are whack for that. And you do have it where it's a former judge here. She just did a video and she was saying, like, when she was on the bench, she said when people start out with their like when they're first arrested and going through arraignment in the beginning stages of the whole criminal case, they'll have 20 people. They got the whole block. Free Pookie. They got the whole block. Then after the first 6-7 months, because it depends on how many motions you file, if you try to do interlocutory appeals, which is to stay the lower court because you don't like a ruling of a motion to suppress or something like that, and you try to appeal it while the case is still going, but your case obviously is not, completed, your case will take longer. So you'll have people that's still waiting a year out on bond, 2 years out on bond because they're waiting on the Court of Appeals. And by the time you get to trial, it's gonna be your mama. Okay. So that does happen where people fall off. It's you got your mama and God at the end of the day. Or you had your daddy, your mama and your daddy and God at the end of the day. So that does happen. And in this case, with it being high profile, I understand why people want to separate themselves, like I said. But to do the kids like that, He gonna cuss all y'all out, and you deserve it. Those tap lines are real. When I worked a program for BOP, Fox continued to express how innocent convos were taken against them as evidence and got time. Real talk. Do not play my yeah, don't be very, very careful. That's why even I do in-person visits, and you can do every now and then I do video visits, but I don't even really be talking that deep on the video visits because and phone, I'm like, don't call me. I don't care if they do got me as an attorney line. I can't guarantee that they not gonna accidentally forget to take don't record off with our conversation because they're looking for the leverage. Like with me doing wrongful convictions, they'll try to find ways to tip them and say, oh, they might have really found some new evidence according to what we saw. We heard. We don't really know. So you have to be careful on phone. So I agree with that. Like you shouldn't really like look at Kanye. You record the conversation to put it out on the internet. Like, yeah, you did show up, but what was your full motive of showing up? Once you found out you couldn't be in the courtroom and you had to go in the overflow, even though they opened up a special room for him, he was Audi 5,000. They said he was there for like 15, 20 minutes. And then he was back out and they was taking pictures of him leaving. Peace 4100 said he should be sentenced to drug, sex, anger rehab for like 2 years straight. No friends, just immediate family. Yeah. Agreed. Agreed. Cause honestly, they should have a lot of this stuff just should the arson case, they investigated it and they couldn't come up with a conclusion. They never tried to arrest him, and I'm sure Kid Cudi gave his name. But you're able to use that in a RICO to try to I guess in theory, it's they call it still an ongoing investigation. They didn't close it out. But it's been sitting there since what, 2016? So they probably wasn't gonna do nothing with it. So yeah. Have you noticed that the transfer conflicts what big news networks are saying? This is the real organ. Yes. I do see some conflicting, and from my understanding from people that are there, they're saying a lot of the big news organizations don't even stay for the whole time. They're getting bits and pieces of information and they're leaving out, and then they're trying to talk to the audience live and all of that, and they're not even staying for the whole things, the whole hearings. Bible lady said in Puff's case, he's gonna only have Miss Janice on her wig. Yeah, that's true, Trey. Well, every time. So victim blaming is this. Everybody expands everything like they expand in this RICO. Victim blaming is somebody. If I say Cassie, it's your fault. He beat your behind. You did that and you deserve that. That was like switching the blame to her for what he did and she didn't do nothing wrong. That's victim blaming. Same thing with like grape. Well, you was in a sexy outfit. You wanted it. You really did want it. Saying because of your outfit, you deserved what was good. You were asking for it, which had people sit back. A lot of people, and I know a therapist on here can say, can probably validate or verify or even expand is that when people are actually assaulted, they blame themselves oftentimes. So because of that, they'll find ways. Well, maybe I shouldn't have walked around with my pants too tight. Maybe I shouldn't have did that. And then the man will say that about, oh, she was looking like a hoe that day. So that's the reason why I did it. Right. So that's what that is. A lot of what we're saying is if you're consenting and there's proof that you're consenting and say, I really didn't want it, but it was in my mind and I never told him, but I'm relaying to him because I don't want him to do it with nobody else and to keep him happy. How do you blame somebody else for that you didn't relay that to? So what they did was Jane Doe, her purpose was to say she actually had texts of where she said, I don't really want to do hotel nights. But then we also know she used hotel nights to hold it over his head when he was with other women to make him leave. So there was an incident where I guess he was with Young Miami or with somebody, and he was at Turks and Caicos because apparently that's where he take everybody. So when they were there, She saw it, found out, and said basically, if you don't bring your behind back today, you won't never get another free car, or you won't never get a hotel night. So he packed his wraps and he rolled. And that's why there was actually a text where and the audio where he said, "You're always using sex against me, and I'm tired of that." That's how I interpreted it before people were looking at that like that was wrong in the audio. But I interpreted that before I heard the testimony of which she used it against him. And I said that. I was like, watch, they're going to have some evidence that she's used this against him in order to keep him away from somebody else, or use this as a so you can't on one hand say I hated doing it. I told him I didn't want to do it. He still made me do it. But then when he's not doing what you want him to do, because in your mind you thought you were the only person he was doing that with. So if he doesn't comply with what I want him to do, I'm gonna tell him he ain't seeing another freak off with me. And I know this your fantasy. So what made her mad about the lawsuit is she found out this ain't nothing new. He ain't new to this, he true to this. He was doing this with Cassie for years. So that's what the lawsuit for Cassie really did and pissed her off. And then she started taking thorough notes and voice and memos and stuff on how she felt Diddy was treating her. Cassie said Diddy never indulged with men, said he's not homosexual. Okay. That's a rumor out there too. They said it was, he got men suing him too. Soup Bone says, since when adults are not responsible for their own actions? In this case, apparently. What? I never heard that. But, I don't want to just say that's the truth, Miss Irreplaceable, because we hear so much stuff out here. Everybody's trying to get some type of exclusive or bombshell moment because so many people are covering this case. So you got to come with something and some catchy clickbait title that makes people want to watch what you want to, watch what you have to offer. I don't do that. I'm gonna say what's in the title. That's what it is. Like it ain't. If you're interested in the truth and straight no chaser, then you come here. If you want the sensationalized, gossipy portion of it that may or may not be true just to get you over there, that's not what I do. So I don't know. I ain't gonna say it would shock me, but I don't know. You said, is being a swinger illegal? No, there are actually, as you guys probably know, there are clubs, people that do this. Thank you so much, Glamour. W1, I appreciate it. All right, y'all. I'm getting off of here for real. We've been on for 2 hours and I was trying to get off way before 2 hours. So I'm gonna talk to y'all later. And we'll be back all over again tomorrow. So make sure you come over here. It'll probably be about 11 or noonish or something, because I'll wait till they got at least a couple of pages of the oh, my back. I wait till they have a couple of hours of the tweets, because otherwise you just sitting there like, well, what you gonna say next? Do, 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 do. Then I gotta start talking about my life and everything to try to fill in the air and the gaps. So all right, y'all. Well, see y'all tomorrow. You guys have a good night.